If you still think carrying a handgun in Texas means you can relax and stop paying attention, 2026 is the year that assumption can cost you everything. Not because you are a criminal, not because you had bad intentions, but because you misunderstood one rule, missed one sign, or relied on something you heard from a friend instead of verifying the law for yourself. Let's slow this down and talk like real people. Imagine you are just living your normal life. You carry a handgun because you believe in protecting yourself and your family. You go to work. You stop for gas. You meet friends for dinner. You attend church on Sunday. You are not looking for trouble. You are not acting reckless. You are simply exercising what you believe is your right. Now imagine that on an ordinary day, you walk into the wrong building, overlook one posted notice, or misunderstand one restriction. In that moment, your firearm stops being protection and becomes evidence. That is how quickly things can change. Texas does allow many adults to carry a handgun without a license to carry, often called an LTC. But permitless carry never meant roleless carry. The laws did not disappear, they shifted, and the people who get in trouble are usually not the loud, reckless types. They are regular, working adults who assume they were fine. The first thing you have to understand is eligibility. Just because you are not a convicted felon does not automatically mean you can legally carry. Texas law and federal law both create categories of people who cannot possess a firearm. Some misdemeanor convictions can matter. Certain protective orders can matter. Some pending charges can matter. Conditions of probation can matter. Even specific court findings from years ago can matter. A lot of people never double-check their own record. They assume that because they were not sent to prison, everything is cleared. That assumption can be fatal to your case. If you are legally prohibited from possessing a firearm, carrying one under permitless carry does not magically fix that. The law does not care that you meant well. It only cares about status. Picture this scenario. You are driving home from work. Your handgun is holstered. You believe you are fully compliant. A police officer pulls you over for a broken tail light. It is a routine stop. The officer asks for your license and insurance. Then comes the question, do you have any weapons in the vehicle? Your pulse jumps. You want to be honest. You say yes, there is a handgun. Now, everything depends on your legal eligibility. If you are allowed to possess that firearm, the stop may remain routine. It might be uncomfortable, but it usually ends without charges. If you are not legally eligible, that same traffic stop becomes the beginning of a criminal case. You could be calm. You could be polite. You could be respectful. None of that overrides eligibility. The law is mechanical in that way. It does not measure your character. It measures whether you were allowed to have the gun. Age has also been an area of confusion. Texas sets 21 as the standard age for handgun carry, but there have been court rulings and policy adjustments affecting how the state handles 18 to 20-year-olds in certain circumstances because court decisions and agency enforcement policies can evolve, especially in a state as large as Texas. You cannot rely on old information. If you are under 21, you need to confirm your specific legal situation with up-to-date, reliable sources before carrying. Now let's talk about something that surprises people more than anything else. Where you carry matters more than how you carry. Many gun owners focus on the mechanics. Should it be concealed or open, inside the waistband or outside, in a bag or on the belt? Those details matter, but they are not what usually trigger felony charges. Location is Texas law recognizes what are commonly referred to as prohibited places. Even if you are otherwise allowed to carry, certain locations can make it illegal. And then there is private property. This is where many mistakes happen. In Texas, private property owners can restrict firearms on their property if they provide proper notice. Notice can be verbal. It can also be written, includes specific types of signs. A lot of people believe signs are suggestions. They are not. You may have seen references to sections 30.05, 30.06, and 30.07 of the Texas Penal Code. Section 30.05 addresses criminal trespass and can involve firearms if proper notice is given. Texas even provides detailed language requirements for certain signs. The wording must be specific. It must be in English and Spanish. It must use block letters at least 1 inch in height and be displayed in a conspicuous manner at each entrance. Sections 30.06 and 30.07 deal with concealed carry and open carry by LTC holders, respectively. Even in the era of permitless carry, these provisions still matter. The idea that signs no longer have force is simply wrong. Property owners may use different notices to address different categories of carry, and if someone with authority over the property gives you verbal notice that firearms are not allowed, that notice counts. Here is how a simple mistake unfolds. You walk into a restaurant. You are carrying concealed. You notice a sign near the entrance, but assume it is about hours of operation. You do not stop to read it. You sit down. Later, when you stand up, your shirt shifts and the outline of your holster becomes visible. A manager approaches and tells you firearms are not allowed and asks you to leave. At that moment, your next decision is critical. If you argue, refuse, or lecture the manager about your rights, you are escalating the situation. If you refuse to leave after receiving notice, that can turn into a criminal trespass issue. The smartest move is simple: leave immediately. You can debate legality later. With an attorney, you do not want to debate it in a crowded lobby with a pistol on your belt. Ego is one of the most expensive traits a gun owner can have. The law does not reward pride. It rewards compliance. You can protect your freedom by swallowing your pride and walking away. Now let's discuss alcohol-related locations. Texas treats certain establishments differently based on how much of their revenue comes from alcohol sales for on-premises consumption. You may have seen a large red 51% sign posted at some entrances. That sign indicates that the business earns more than half of its income from alcohol sales consumed on the premises. Carrying a handgun into such a location can be a serious offense. People often rationalize. They say, "I am not going to drink, so it does not matter." Or they assume that because the building looks like a restaurant, it must be fine. But some establishments operate as restaurants during the day and shift into bar-like environments at night. Revenue classification is not always obvious from appearances. Imagine you meet friends to watch a big sporting event. The place is loud. Drinks are flowing. You are focused on finding a table. You walk in without scanning for signs. Later, law enforcement responds to an unrelated disturbance, and suddenly your presence with a handgun in a 51% location becomes an issue. That is not how you want to discover you made a mistake. Even outside of 51% locations, intoxication is its own danger zone. Texas law addresses carrying while intoxicated. Intoxication is not limited to being visibly drunk or stumbling. It can be based on loss of normal mental or physical faculties due to alcohol or other substances. Saying "I only had a couple of drinks" is not a legal strategy. If you are carrying, the safest approach is to avoid alcohol entirely. If you plan to drink, leave the gun secured legally and safely elsewhere. Now consider prohibited places beyond private businesses. Many people can list schools, courthouses, and secure areas of airports, but there are other environments that raise risk. Certain government offices, hospitals under specific conditions, amusement parks meeting statutory criteria, racetracks, and locations hosting high school, collegiate, or professional sporting events. Details matter. Sometimes restrictions apply only to specific areas within a property. Sometimes signage and security checkpoints play a role. A practical mindset shift is to think in terms of risk zones. If you see metal detectors, bag checks, heavy security, presence, or large posted warnings at entrances, treat that as a signal to pause. Do not assume. Confirm before you enter. A few seconds of caution at the door can save you months of legal trouble. Large public events are another area where confusion happens. A fairground or festival may feel open and casual. Families everywhere, music playing. It feels public, but the property could be under special rules for the duration of the event. There may be posted restrictions at controlled entrances. Walking past a sign because you were distracted does not erase its legal effect. Asterisk. Now let's talk about vehicles. Many people believe their car is a kind of legal bubble. It is not. While Texas law does allow certain forms of vehicle carry, your conduct during a traffic stop matters enormously. Sudden movements, reaching under seats, or digging through compartments can alarm an officer quickly. Keep your firearm stored in a consistent, secure manner. Avoid tossing it loosely into glove boxes or under seats where it may slide around. During a stop, keep your hands visible. Inform the officer calmly if required by law, or if you choose to do so. Ask before making any movements. Remember that what feels normal to you can look threatening to someone standing outside your window who does not know you. And again, none of these tactical tips override eligibility. If you are prohibited from possessing a firearm, Having it in the car just for transport may not protect you. The real protection is ensuring you are legally allowed to have it. In the first place, rental housing adds another layer of complexity. Some leases contain language prohibiting firearms. Texas has enacted laws that limit how landlords can restrict firearms. In certain residential contexts, and in some cases, tenants may have defenses related to possession within their own dwelling. But that does not mean every situation is identical. The type of property, the specific lease terms, and the areas involved can all matter. Moving a firearm from your apartment to your vehicle through common areas may raise different questions than possessing it inside your private unit. Instead of assuming you can ignore every lease provision, understand your specific situation. If necessary, consult an attorney who understands Texas firearms law. Your goal is not to win an argument with a property manager. Your goal is to avoid charges when you look at real felony gun cases. Many do not involve hardened criminals plotting harm. They involve regular people who made a bad assumption. They carried while technically prohibited. They ignored a sign. They refused to leave after being told. They mixed alcohol and firearms. They walked into a restricted location without noticing. It only takes one person to notice your firearm and call authorities. It could be a coworker who dislikes you. It could be a customer who is nervous. It could be a security guard who has been instructed to report every visible weapon. Once that call is made, you lose control over how the situation unfolds. So what habits can protect you in 2026? First, conduct an honest personal legal check. If you have any past arrests, deferred adjudications, convictions, or active court orders, confirm your current status through reliable, up-to-date sources or legal counsel. Do not guess. Second, develop a doorskin habit. Every time you approach a building, pause, look around the entrance, read posted signs, look for alcohol warnings, 51% notices, or references to penal code sections. Notice security features. Make your decision before you cross the threshold. Third, if you receive verbal notice that firearms are not allowed, leave immediately, calmly, without argument. You can always return unarmed or choose another establishment. Fourth, separate firearms and alcohol. Make it a firm rule for yourself. This single discipline can prevent a large percentage of avoidable charges. Fifth, prepare for traffic stops in advance. Know where your firearm is. Keep it secure. Plan to keep your hands visible and your movements deliberate. Sixth, stay current. Laws change. Court decisions modify enforcement. Agency policies shift. Information from a year ago may not reflect the present reality. Regularly verify that your understanding is still accurate. The core idea is simple. Texas may allow many adults to carry without an LTC, but it does not excuse carelessness. The rules about who can carry, where you can carry, and how notice works remain very real. The fastest way to face life-altering consequences is to assume you are legal without confirming. This is general educational information, not legal advice. Laws can change, and your individual circumstances matter. If you need guidance about your specific situation, consult a qualified Texas attorney who can review the details of your case. Your freedom is worth more than a guess.